The legal environment of business is a legal agenda. It is going to help to run the legal process of the organizations. It is going to help you as strategic managers to make legal decisions and run organizational operations. Also, it enables managers to run the whole operational work smoothly. The legal environment is helping managers to analyze legal boundaries of operational works, and these are the only ways to help you deal with all government related legal issues. One knows the limit and limitations of business through legal environment. Legal factors are factors that essentially bind the society to the business owned. Legal factors are a part of legal environment that ensure that business is not causing any sort of harm to the public or people working in it, or the people in the society who are much likely to be affected by this business setup. The laws which are passed by the government for business operations are a part of the legal environment. In every country, the government regulates business activities. These regulations of the government are considered as legal environment. So, what are the characteristics of legal environment? The characteristics is that legal environment of the business is always free from external and internal threats. More than 23 countries implement their transport-oriented rules regarding these policies. Every wing of business sector is connected without facing any haze. For this purpose, proper communication between interdepartment is important. World distribution of major legal traditions include that there are three major legal systems of the world today, which consists of civil law, common law, and religious law. In some countries, you would also see the criminal law. However, like for example in India, however, in each country often develops variations on each system or incorporates variations on each system or in its features. Civil law. Shamash, the Babylon sun god, handed over King Hammurabi a code of law. Civil law is the most widespread system of the world in the law in the world. It also sometimes known as European continental law. The central source of law that is recognized as authoritative are codifications in the constitution or statute passed by legislature to amend a code. Civil law systems were mainly derived from Roman Empire and are particularly the Corpus Juris Civil was issued by Emperor Justinian in 529 AD. Civil law was partly influenced by the religious laws such as canon law and the Islamic law. Civil law today, in theory, is interpreted rather than developed or made by judges. Only legislative enactments rather than judicial precedents are considered legally binding. However, in reality, courts do not pay attention to the previous decisions, especially from higher courts. In case of common law, King John of England signed Magna Carta, common law, and equity. Those are systems of law whose sources are the decisions in cases of judges. Alongside every system will have a legislature that passes new laws and statutes. However, these do not amend a collected and codified body of law. Common law was developed in England, influenced by the Norman conquest of England, which introduced legal concepts from Norman law and Islamic law. Common law was later inherited by Commonwealth of Nations and almost every former colony of British Empire. The doctrine of stare decisis or precedent by the courts is a major difference to codified civil law systems. Common law is currently in practice in Ireland, most of UK, as well as Australia, India, South Africa. In addition to these countries, several others have adopted common law system into a mixed system as such. In European Union, the Court of Justice takes an approach mixing civil law with attachment to importance of case law. One of the most fundamental documents to shape common law is the Magna Carta, which placed limits on the powers of English kings. It served as a kind of medieval Bill of Rights for aristocracy and the judiciary who developed the law. In case of religious law refers to the notion of religious system or document being used as a legal source, though the methodology used varies. Christian common law is more similar to civil law in its use of civil codes. Islamic Sharia law is based on legal precedent and reasoning by analogy, qiyas, and is thus considered a precursor to common law. The main kinds of religious laws are Sharia in Islam, Halakha in Judaism, and canon law in some Christian groups. In some cases, these are intended purely as individual moral guidance, whereas in other cases they are intended or may be used as a basis for countries' legal system. The latter are particularly common during the Middle Ages. Islamic legal system of Sharia is most widely used religious law and one of the three most common legal systems in the world, along common law and civil law. During the Islamic Golden Age, classic Islamic law had a fairly significant influence on the development of common law and also influenced the development of several civil law institutions. A very important outbreak of the legal system, which forms the foundation for any business, is the contract law. Any business relationship involves a contract. Contract law describes how business exchange goods and services. Whether you write your own contract or have a business attorney draft one for you, it is a good idea to know what goes into a legal contract. So now we are going to discuss an article regarding the contract law basics, types of contract, what smaller owners can expect to do. So, what is a contract? Contract is a legally enforceable agreement between two parties. Contract must contain the elements like an offer by one party for goods or services, an acceptance of offer by the other party, consideration for the offer. There must be a bargain for exchange of value to benefit both parties from contract. Mutual agreement. Both parties must agree to the terms of contract. If either party changes any of the terms, it becomes a counter offer. For instance, Joe offers to paint Fred's house for $100. Fred accepts. Consideration is $100 Joe gets for painting the house, and Fred's new painted house is provided at the end of the contract. So, what are the types of contract? Contract come in various forms. They are valid, enforceable, as long as they contain the elements as discussed. That is, there is an offer by one party for goods and services. An acceptance of the offer by the other party is being made. There is a consideration for the offer. That means there must be a bargain for exchange of value to benefit both parties from the contract. Again, there has to be a mutual agreement. That is, both parties agree to the terms of contract. If either party changes, it becomes a counter offer. Other elements which may be necessary depending on the subject matter of the contract of the parties is the verbal contract. A verbal contract is as valid as any other contract. It may be difficult to prove in the court though. Written contract. A written contract includes all elements of contract plus information. Business agreements may include delivery requirements, state laws and codes, boilerplate language on warranties and liabilities, a written contract in evidence in court in case of breach of fraud. Universal Commercial Code, this governs the sale of goods over $500. UCC wants all contracts in writing. Service contract, including employment agreement, professional services, anything involving non-tangible products. Real estate contracts must always be in writing to satisfy statute of frauds. Breach of contract basics. So when do we actually say that there has been a breach of contract? A breach of contract exists when one party fails to fulfill its obligations. There are four types of breaches. Actual breach occurs when one party does not perform. Say, for example, Joe does not perform Fred's house, so he's in actual breach of the contract. Anticipatory breach occurs when one party expects the other party to breach and breaches first. Some business practices allow these anticipatory breaches for legal reasons. Minor breach occurs when the breaching party has breached the contract in small way. That is, if Joe said he would start painting at 9 a.m. but didn't begin until 9:30, that would be a minor breach. Material breach. Material breach means that the breaching party has failed in a way that causes significant harm. The material breach is usually grounds for legal action by non-breaching party. Contract issues leading to breach of contract are a serious problem for business owners. If you operate a small business, you should have ready access to experienced attorney for legal advice. The time frame to file a lawsuit is narrow, and the evidence needed to prove your case can be hard to obtain without legal help. So, how do you go about enforcing a contract? Public policy and common law determine contract enforcements. A contract that is void on its face is unenforceable. Other types of unenforceable contracts include lack of capacity, misrepresentation, unconscionability, and mistake. So now let us look at each of them one by one. Lack of capacity. Both parties must be able to consent to the agreement. Some people do not have the legal right to consent because of age, mental condition, or legal status. Misrepresentation, fraud, duress, or undue influence are all grounds for voiding a contract. Unconscionability. If the terms of the contract are grossly unfair, lopsided to be said, or if the parties' bargaining positions are unequal, the court may invalidate the contract. Mistake. A mutual mistake happens when both parties are mistaken about the terms of contract. There is a misunderstanding. This can void the contract. A unilateral mistake occurs when one party is mistaken. If the other party was aware of the mistake and used the error to their advantage, it becomes a fraud or misrepresentation. So, how can a court actually handle legal issues with a contract? It all depends on the contracting party as to what the contracting party knew and when the error occurred. Void contracts are unenforceable from the very beginning. A void contract may be illegal or impossible to perform. The court will not and cannot enforce them and will cancel the contracts. Voidable contracts are those cancelled by the parties or which become void by law. For instance, a minor child cannot legally sign a contract. But if they do, they can accept the contract terms when they turn 18. Otherwise, the contract becomes void. Therefore, all business deals with the contracts, even if they are unwritten, such as transactions involving goods or services. A contract is a legally binding agreement, and even an honest contractual mistake can cause serious problems. In terms of what? In terms of fighting a civil case or a criminal case or having legal action taken against the business owner. Small business owners should have at least a basic understanding of the contract law or seek legal help.